This time the topic that is given to me is restorative justice principles and practices. Before I actually start with the topic, let me just tell you the significance of whatever is written over here. You might just want to check that the word justice has been typed twice in this slide. One is there in the title of my presentation, that is restorative justice, and the second one, that is the school where I work in, NFSU, School of Law, Forensic Justice and Policy Studies. So with this I can say that justice is something that we all pursue in our life. We at NFSU, we try to pursue the justice through the medium of forensics. And we all know that forensics is an important medium in the criminal justice system. So through that way we try to explore the justice by way of providing expert opinions and various medical examinations or variety of examinations that forensic science does. But here I am today going to deliberate upon a topic of restorative justice. And let me tell you friends that this concept is something that everyone must understand. Like, just as an exercise, just look at to the world around us, look at to the geopolitical and societal situation of our country. You being law students, I assume that you are reading judgments and you are just carefully, looking around and understanding that how our system is working, how the legal sphere is working, how the judiciary is working. And when we see all these things, then we understand that what is the pattern or what is the method by which this entire criminal justice system works. I would like to drag your attention to some of the judgments that Supreme Court of India has delivered in this very month of March. The last month of March. That on 1st of March there came an acquittal. The acquittal was in a case of Abdul Wahid versus State of Rajasthan, a 36 years old murder trial, and it resulted into acquittal. There are many acquittals that you might find. Now, as a law student, I think that whenever acquittal judgment comes, that's how you should get channelized, you should get alert, and you should explore it that why acquittal was there. There must have been an arrest, there must have been so many procedures, there must have been witnesses, and still the case results into acquittal. Okay, fine, we are not unhappy with the acquittal. One innocent person was acquitted, fine, but what about that person who actually committed the crime? And above all, what about that victim who has got nothing in his hand, who just waited that the justice would be delivered to him, and now the only person to whom he is looking towards, that is judge who has acquitted the accused person. So with all these things, it is very important we should deliberate upon the quality of justice, the medium of justice. Do we need any other medium of justice? Is our criminal justice system sufficient to deliver what we expect from it? Here I just found a shloka that you must have read it. The English translation is quite famous. Even Supreme Court of India judges, they often cite it. Law is the king of kings, and even the weak may prevail over the strong. This is Brihadaranyaka Upanishad shloka. And we all know the importance of this shloka, that yes, law is almighty. Like law, if you just take away the law, the society would fall apart. So if we have laws, then why justice is not served? Because nobody can define justice in a concrete way. It's an abstract term. But yes, we have laws, not just laws, codified laws. So with the help of codified written laws, we want to explore that destination, which is very subjective, which is abstract, which is hard to achieve, and that is the real struggle, my friends. Here comes a slide that I've prepared. Now let's delve into the topic, restorative. What is restorative justice and for whose benefit this term is devised? You can take the example of anything that is happening around you. So many crimes are happening. As soon as a crime happens, there is an offender. Now we expect that the offender should get punishment. What the law prescribes, we have many punishments, we have many sections, many laws, local and personal laws are there, special laws are there. Those prescribe the punishment. And we know that in criminal law, the byproduct or the end product is always the punishment. That is what the criminal law stays apart from the civil law. In civil law, you might get injunction, you might get other remedies, but in criminal law, it is always a punishment. Punishment in either of the categories that is mentioned in section 4 of BNS. So ultimately, the victim gets nothing, and that is the reason. What type of justice we're talking about? Justice for offender or justice for victim, or justice to both? That is the question that we must ask to ourselves. Here comes various procedures that happen. As soon as a crime happens, you get an accused person, FIR is lodged, followed by the arrest. Then you go and collect the witnesses. The crime scene management will be there. You get witnesses and their statements recorded. Then you might conduct medical examinations. The forensic report might come from the FSL laboratories. Then you assemble everything and you put the charge sheet because you're convinced that yes, we have sufficient material with us to conduct the trial. And after charge sheet, you bring the accused person before the court and ask him, do you plead guilty? If he says yes, the trial ends there. But if he says no, I want to face the trial, there comes your trial. And at the end, if the conviction is not secured and if there is an acquittal, then that is what the victim just silently sits and just expects that what is to be done now, because I am harmed, I am injured, I am hurt, I have lost someone. Or if the victim is died, then his soul might wander here and there and expect that yes, justice might be delivered to someday. These are the various experiences that a victim undergoes. Imagine that you have been hurt by someone, physically, mentally, emotionally. These are the obvious stages by which we all go through. First is shock and disbelief. How this can happen with me? That comes the first stigma on our mind. Slowly our mind starts absorbing the shock or the trauma. Then sometimes our senses that get numb. If the injury is like something extraordinary, then our senses they stop working. Then comes fear and emotional distress. What is to be done? Suddenly we realize that society around us is looking towards us. How can we, make eye contact with them? How can we make eye contact with ourselves? That is what we see. Then we think that we should report the crime. And this is the very crucial phase, because most of the crimes, they go unreported. And if the case is not reported, then how can we even think about the justice? Even if you cross this phase, report the crime, then comes legal processes, your judicial journey, several visits to the court, the hearings, there are adjournments, sometimes judges is on leave, the witnesses are not turning up, the prosecution has some other things, all this court kacheri that things start. Then comes societal recognition, reaction and stigma, because you are prolonging with your hurt, your injuries, you don't know how to figure out. You might have lost your finances because it's a court matter. You might have lost your job because of all these things. And ultimately then you have that financial, practical impacts. So these are the things that everyone goes through. Above all, at the end, everyone wants a closure. We want an apology from the offender. We want a closure. We want that repentance. We want to see that on his face or her face. But we have to wait because that's not in our hand. We live in orderly society. We are a civilized nation. And that's the reason if somebody does something wrong against us, we are not authorized to take the vengeance or avenge. That is replaced by the prosecution. The state will take the revenge on behalf of you through the procedure established by law. And that is how it is not in your hand that you can see that the justice is done right there. Sometimes the mob, sometimes the people, they take laws in their hand and start doing justice immediately, but that is illegal. We all know that. So all we have to do is wait for the justice to be delivered by the court. So restorative justice is what then? It's a concept where justice is delivered in a different way. It is not a formal court process. It's not a formal codified structure of laws. It is something beyond that. And above all, it recognizes the victim and the wrongdoer both, but in a different way. It does not recognize the accused to punish it. It does not recognize the victim just for some remedy. It looks into the aspect that how can the wrong to be undone, how we can compensate the hurt, how can we repair it. And these concepts we can find throughout the world. There are many tribal areas of Africa. Even they, as a community, that they have given us these ideas. That one of the important, very famous communities, Ubuntu in South Africa, they have this motto that I am because we are. They encircle themselves and they focus on that. How can we forgive? How can we, exercise empathy? Now just imagine these things. Somebody has committed crime against you and you're just asking him to just be with you, and this kind of circle are there, and then you're asking them to repent, or they are asking to forgive. We can't even imagine all these things in our society. But yes, the elements are quite there. Or if you just go and check in Native American peacemaking circles, that's how they all come together and they they try to find a solution. There are many other tribes across the world, like Pacific Islander, Ifoga, that is Samoa, that is the method by which they try to reconcile, they try to forgive the offenders, and that's how they try to find the solace. How can we repair the wrong that is done by the offender? Yes, punishments could be there, but those are not the punishment that we see in the law books. Those punishments could be different. Those punishments are meant to benefit or compensate the victim and not just retributive punishments. Here comes the very famous theories of punishments that we all know. We all know these concepts of lex talionis, an eye for an eye. Whatever is injury done, you have to do the exact same injury to the offender. Then we have the doctrine of just deserts, in which whatever the culprit deserves, give him that punishment. So these could be variety of theories of punishment that we can compile. Then we all know the retribution. It is again a kind of lex talionis, but in retribution, it could be in any other form. It might not be always eye for an eye. It might be a leg for an eye or something different. Then we have deterrence. We want to set an example that nobody should ever think about committing the same crime. So we give exemplary punishments under deterrence theory. Then we have shifted our focus towards rehabilitative punishments, rehabilitative theories, in which we focus that let's focus on the accused, let's focus on the offender. I belong to Pune, and Pune has a very famous jail, Yerawada jail, in which even Mahatma Gandhi and Dr. Babasaheb Ambedkar, they were kept there. So in one of the barracks, it was written that Mahatma Gandhi's quote that consider jails as hospitals. Consider jails as hospitals and criminals as a patient. These are the hospitals that cure the disease called crime. That is how the philosophy given by Mahatma Gandhi. So sometimes we try to follow it. We have various jail reforms. So rehabilitative theory is there, but that is focusing upon the accused person or the offender. And then now we have restorative justice. Here we try to talk about not just accused, not just offender, but the victim. Because at the end, he is the one who awaits for the justice. We have ample of provisions, ample of safeguards to save the rights of the accused person. We have so many constitutional remedies. Article 20 is full of those three precious rights against the self-incrimination, ex post facto law, or the double jeopardy that is there. Right to remain silent for again given to the accused person. What about the victim? So victim is something that is still awaiting. And what kind of punishments we're talking about? Consider the most strict and irreversible punishment, death penalty. See the map. Around 113 nations have abolished it. Now we know that death penalty is not given for petty matters. It is always given for very severe matters. These are the countries who have abolished it. The entire European Union has abolished it. Why they are abolishing it? Don't they fear that crime rate might touch the sky? Exactly. The crime rate has not increased there. Rather, it has collapsed. Because they are resorting to some other kind of justice, and that is restorative justice. Of course, India, USA, and there are many other countries, they are still retaining the death penalty. But why I'm showing you this map? Because the punishment, even the most severe punishment, is not serving its purpose. Technically, if the death penalty is there, then there should not be any murder. Are these criminals not fear of their lives? But yes, every day if you just open the newspaper, some massacres, some kind of murder, new forms of murders that we are seeing, nobody has even thought of about 5 years ago. And that's the reason we have to talk about restorative justice. Now, considering our knowledge, what law that we study from the first day of the first lecture of criminal law, actus non facit reum, nisi mens et rea. Nothing constitutes crime unless done with guilty mind. Fine. And we have punishments. Earlier section 53 was there in IPC, now section 4 is there. Of course, yes, community service is again added into that. Yes, punishments are there. We are talking about criminal justice system, but is it serving the purpose? And that's the question, and the answer would not be found in a day or two. It's a process. And that's the reason I once again thank to the organizers for giving this topic or bringing this topic. We have to talk about this. I mean, you just ask these questions to yourself. Where exactly we try to compensate victim apart from victim's compensation scheme? The judge has their own powers and duties. The investigating officer has all the codified sections and powers. Accused has adequate safeguards. Recently, we have come up with new criminal law regime from 1st of July 2024. Yes, we are talking about it. Much has been talked about it. We are bringing the victim at the center of criminal justice system. But what are we exactly giving to him? Handful of rights such as at what stage the investigation has reached. You have to inform within 90 days. Then you have to give the copy of FIR free of cost. And then you have some of the sections in which medical examination, there are so many things that we give. But in corporal nature, what does he get? At the time of judgment, does he have any say? You might say special public prosecutor is there, he can, or the victim can appoint his private lawyer. What rights are given to that lawyer? How much weightage we actually give to the victim? And that is the question that we should ask. And then you will understand the severity of these acquittals. Then only you will understand what is happening around us. And one more thing, consider yourself as a victim and who is awaiting years together to get the justice, and when you get nothing, and that's the reason this is a midway. Don't take away, don't collapse your criminal justice system. Let it be there. We have reached to this spot by enormous methods, by enormous laborious efforts. We used to have the CRPC of 1898, which we managed in 1973. In 1973, we prepared our CRPC, by which we managed till 2024. There are many amendments that were carried out. Law Commission of India reports are full of recommendations. There are so many changes that we have done. So this system is not supposed to be collapsed, but why not there should be a parallel system? Why not there should be an innovative approach to deliver the justice for eligible cases? Here I am not talking about Lok Adalat. I am not talking about ATR. Those things are different. Here we are talking about victim who has been hurt and how can we compensate it through the medium of accused. So restorative justice does not preclude, does not prevent accused from participating inside it. It rather wants that accused should participate in it along with victim, and both should work out a solution by which even the society could be benefited. That is what the concept of restorative justice is. If we just compare our traditional criminal justice system, which mostly relies upon retribution, if you see our punishments, as soon as the gravity of the offense increases, the punishment also range is high. Like cognizable offenses, all the offenses from 3 to 7 are cognizable under Schedule 1 of the BNSS. But again, then from 7 years till death penalty, again super severe offenses. For that, punishment is higher, 10 years, 20 years, 14 years. So, some or the other way, we are relying upon the retribution. And what questions do we ask during investigation? What's the offense? Whether the offense has caused? Who has committed the offense? And what's the punishment? This is the entirely nutshell of our criminal justice system. Here are the questions that restorative justice asks. First, what is the harm? What is the nature of the harm? Secondly, how do we repair it? Is it curable? How can we repair it? Thirdly, who is responsible for repairing the harm? Rather than asking who is responsible for the harm, we are asking a different question: who is responsible for repairing this harm? So this way, these two systems could be differentiated. Now, we can definitely pick restorative justice if we see the questions that we ask, if we see the things that is written over here. But these are not the codified things, and it could be subjective. From case to case basis approach could be there. But yes, as a law student, as a legal mind, we should start thinking about it. There's a high time for that, because we don't know that when we ourselves would be a victim, and then how can we just expect justice sitting silently and waiting for the judgments to come? There are various approaches in sentencing. If you just see, there are many judgments. In criminal-centric approach, you can see that Santosh Kumar Bariar's case, the accused person was not given death penalty because these things were brought to the notice of the court that they were unemployed. They committed the murder. It was a murder trial, but they were not given death penalty. They were given death penalty, life imprisonment. Why? Uneducated, unemployed people committed crime. They were not the hardcore offenders. The benefit was given. Secondly, crime-centric. We have Machi Singh's case, a very famous case in 1980s. There are 5 categories that were given. Then we have judge-centric, because we know that sometimes the bench that matters. Not every bench or not every judge gives the same verdict. So again, they are the human beings. So that might affect to their justice delivery system. So there are many judgments like Sangeet versus State of Haryana. You can read how judge-centric approach has been discussed by the Supreme Court. And then you have victim-centric. There are a few judgments in which Even the Supreme Court has started talking that there should be victim impact statement, victim impact assessment should be there. And it is not just the word play, it should be organic. You should find out what is the impact on the victim and how can we compensate it. So when we talk about restorative justice, what exactly is the position of victim inside it? Firstly, understand who is victim. Here is the definition of very famous Convention of United Nations, 1985. Victim pertains to a person who individually or collectively have suffered, individually or collectively, harm, physical or mental injury, emotional suffering, economic loss, substantial impairment of their fundamental rights, almost everything. Through acts or omission that are in violation of criminal laws operative within member states, including those laws prescribing criminal abuse of power. Almost everything that we already know. That's the difference between crime and offense. Offense is something that is prohibited by law. When you have a section, then act becomes offense, otherwise it just remains the crime. So United Nations has framed some of the definitions. Then we have the branch of victimology. It's a full-fledged, developed, researched branch. It started, victimology word was first used in 1947 by Benjamin Mendelsohn. He was a famous criminologist. He has started thinking about it. You can just refer to his some of the literary works. But what exactly restorative justice talks about? It talks about reparation, amendment, focus on acknowledging and repairing the physical, emotional and financial harms caused by the crime. So firstly, you need a reparation. Second, respect. Respect for what? Treat all the participants with dignity, compassion. Firstly, restorative justice cannot compel the accused person to participate. It is merely a voluntary system. So respect should be there. Then voluntariness, again, exactly. There should be voluntariness. All these elements you might find in plea of bargaining as well. That is a very important section in CRPC as well as in BNSS. And voluntariness is something that is very, very crucial. As soon as the judge finds out that it is not a voluntary application, they can reject it, that we all know. So voluntariness is very important. Then comes inclusion, foster and support the meaningful participation of those affected, including victims, offender, their friends, families and communities. See the participative approach. This we cannot expect from the regular criminal justice system. Because courts can deliver the justice, but the court can deliver the verdicts. But you require the participation of community to absorb that justice. And that's why sometimes we have jails, sometimes we have open jails, sometimes we have community services. Even the society needs that participation. Then you have empowerment. Empowerment of what? Enable participants to communicate openly and honestly. This is about admitting the guilt. That is what you do in the criminal trial as well. But there you have right to remain silent. Here, silence won't work. You have to one step ahead and admit it. And once you admit it, there could be solutions. Then there is safety to attain physical, emotional, cultural and spiritual safety, well-being of all the participants that is ensured. Further, you have accountability. Assist those who have caused harm to acknowledge and take responsibility of the harm. These things rarely happen in our courts. In fact, there are cases in which till the stage of execution, the accused person says, I am innocent. A very famous that is, I think, Amrut Bhushan Gupta versus Union of India, 1976. In one of the important cases in which a person has killed 3 children, he literally burnt them alive. And then he took the defense of insanity under section 84 of IPC. This case has become so prominent that Supreme Court or the High Court, they may distinguish between whether it's a legal insanity or medical insanity. Medical insanity, that is something proved by the certificate of doctor. Legal insanity is something you prove by the eyewitnesses, res gestae. That at the time of commission of offense, whether you are insane or not, he brought several certificates, but that was rejected. And Supreme Court hold that the legal insanity is not established. He was given death penalty, he was executed, but till the day of execution, he was saying that I am insane, I don't know what had happened. This case, by the way, has also quoted by Supreme Court of Pakistan. That case becomes so prominent at that time that we really don't execute a person who is claiming unsoundness of mind. But this is an exception. So, accountability is something that is very, very important. Then comes transformation. provide opportunities for understanding, healing, and change. Healing is something that we want, and this way we can achieve the justice, not merely the punishment. Now, you inside your mind form two compartments. One side you have your criminal justice system, the other way you have restorative justice. Find out at what stage you can bring that harmony between these two. At what juncture, at what provision of law, you can think that here we can resort to this reliable way. In international perspectives, there are many conventions. One of the prominent is Declaration of Basic Principles on the Use of Restorative Justice Programs in Criminal Matters, 2002. It talks about three important aspects: restorative process, restorative outcome, and the parties. Much has been talked about how to create that ambience, how to bring them together, and how individuals and communities should come together to find out the solution. They should participate together. You wonder that Australia has a full-fledged legislation on it. The name is Crimes Restorative Justice Act 2004. Now imagine a law in India like this kind, that you have a full-fledged law that is talking about restorative justice. We have criminal laws, we have plethora of laws that punish. Here it is something different. What is the speciality? See the objectives. To ensure that the interest of victims are given high priority. Secondly, to enable access to restorative justice at every stage of criminal justice system, at every stage. And thirdly, to enable access to restorative justice in relation to offenders and offences not to deal by criminal justice system. It also recognizes those acts or those offences which are not generally recognized in your system. Even because sometimes emotional damage that we cannot quantify. You must have studied it in contract or sometimes in some of the laws in which remoteness of damages. How can you quantify it? So there you require these kind of laws that may give you that option that how can you compensate it. It has these kind of salient features. Firstly, it is applicable to eligible victims, eligible offenders. Then there will be referring entities. Director General post is appointed, Director General for accused, for victims. They may make recommendations. There is no compulsion to participate. It is available for less severe offences, family violence, or even sexual offences as well. It also recognizes child offenders, young offenders, and adult offenders. It's a very interesting piece of legislation. I think you must visit it and just have a look at how Australian system works. And there are many new approaches of restorative justice, like creative restitution, that is suggested by Albert Eglash. So you might read it later, that because I am leaving this PPT for you, because due to paucity of time I might not be able to deliver or to touch to every slide. Let's go further. Indian perspective. This is something important that I want to share with you. We all know that since the framing of the constitution, we have that method that borrowed from various sources. We pick whatever is good across the world and then we bring it and we make it Indianized. That is good approach because that's where you can have best practices across the world. Same goes with restorative justice. One thing I think since last half hour you must have understood that restorative justice is something that we cannot immediately implement from today itself. There requires legal scholars, judicial minds, executive machineries, political will, good legislations, parliamentary participation, good debates, analysis, surveys, scientific experiments, and then you might come up with some solution that you can do. Till then, understand these provisions. Here's a very famous case. I just want to quote this. This case I often quote, Ramesh Kumar versus Ram Kumar. The judgment is delivered by the Haryana High Court. A very simple case of murder, and parties suggested that we are somehow related with each other. Allow us to pay some money and just withdraw the charges of murder. Now, whatever criminal law that you have learned, that it is not possible. Once the offense is done, the only way by which we can withdraw the FIR is by 482 of CRPC, or at least there should be acquittal or release, something like that. Here simply the High Court allowed it, fine, and then it was noticed by the Supreme Court, and this is what the remark given by Supreme Court. We can only say the judgment of High Court has left us shocked and perplexed. We are at total loss to understand it. The entire system of administration of criminal justice is reduced to mockery. Courts are to dispense justice, not to dispense with justice. This is what the Supreme Court opined. Why? How can you just say that the parties can mitigate? How can you just allow the money to be given and withdraw the charges of murder? You have again reduced the punishment as well. If you allow this, those who are having sufficient resources, they won't bother for long. There might be murders and you just have money. Can you give such license to kill? That is what the question asked by the Supreme Court. Imagine that era that where Supreme Court has thrashed down all these things, and now you have the era in which victim compensation is given. We have the concepts that let the compensation come from the pocket of offenders. So this is the change of era. Here is the definition. Old definition is under CRPC section 2WA. Victim means the person who has suffered any loss or injury for which the accused person has been charged. If you want to call yourself as a victim, the accused person should be charged. That is what the victim's definition used to say. Now this is the new definition under section 2Y. Merely a person is accused, that is sufficient. You don't have to wait that he is charged. So see the time of trial or see the efforts that you have to take to make him charged. Till that duration, your status is just merely an aggrieved person and not the victim. So here, that entire time gap has been removed under new law. See the skill of drafting, that you have achieved that goal by framing some sentences. So that is how, this is the new definition. Please have a look on that. You might get some insights. Then we have victims' participation in legal processes. As we know that we have section 18.8 of BNSS that a private lawyer can be given, because victim cannot directly go in the court and start pleading about himself. Yes, it is allowed in some cases, but normally the prosecution does it. So here, victim has to wait with the prosecution. They cannot just go ahead and start doing what they want. That is what is already mentioned. Then what about victim's participation in proceedings? We have a shift. Earlier we have a case of 1999 Shiv Kumar. It was prohibited. No, a victim cannot go and just conduct the prosecution. But the rule was literally diluted in one of the cases, JK International. Yes, we may allow to intervene and play a primary role in prosecution. But again, the debate is now settled. Rekha Murarka's case, it is not possible. Only assistance. The prosecution has to be conducted by prosecuting officers. There cannot be a personal intervention by the victim. But here comes the victim impact statement that Supreme Court is talking about. Justice Lokur has talked about it. That it's the time that we should start thinking about it. We are not denying the rights of the accused person, but we are promoting the victim assistance. We want to find out that what victim requires, and for that, the Supreme Court has suggested a scheme of victim impact assessment. Here are some of the procedural insights. You all know that we have JJ Act, Juvenile Justice Care and Protection Act 2015. It has variety of sections. Juvenile Justice Board is there. They have certain powers to give a customized kind of treatment to the offenders. That is there. You have plea of bargaining that is suggested. Of course, the success is still debatable. We have not seen the enormous success in plea bargaining in India. So that experiment is still in the stage of experiment. Then we have section 358 of BNSS. Earlier it used to be section 235, pre-sentence hearing. At the end of trial, it was expected that a hearing to be given to the accused. Now imagine you are a judge, you have conducted the trial, you have checked the witnesses, examination of witnesses over, and now the case has almost reached to the stage of conviction. There you have to take a pause and give a hearing to the accused person. Even you can take the case of death penalty, still the same process has to be followed. I'm talking about trial before set of court of sessions. So trial has to be adjourned, give a hearing to the accused person, let there be a discussion between defense and prosecution about the quantum of punishment, and then you can go ahead. A very famous case of Alauddin Mia versus State of Bihar, 1989. The Supreme Court has analyzed that how you have to literally adjourn the proceeding. Recently in 2013, Supreme Court has stated in one of the cases, Babasaheb Kamble versus State of Maharashtra, no need to adjourn, just give sufficient time. Now we are giving time to the accused so that quantum of punishment can be fixed. Imagine at that time we are giving some intervention to the victim, that what can be done to compensate, not in terms of money, what can be done to find out the solution, how can we undo that harm, how can we do something so that before or At the time of giving sentencing, victim will get some kind of solace, some kind of relief. That is not in the law books. That you might think. This is a very powerful section. If we talk about restorative justice, these two concepts are very famous. Circle sentencing, to bring everyone together and discuss, or restorative cautioning. If these things are already there in restorative justice, why can't we just do it there? You have so many rights for the accused person. You're safeguarding his right to remain silent. Or if I can just remember, earlier we had CRPC of 1898, in which we had section 367(5) that said, if you want to give death penalty, imagine the era 1898, it is pre-constitutional era. That section says if you want to give death penalty, then you have to give special reasons why are you not giving. That means death penalty becomes the mandatory rule. And if you give the life imprisonment, then give special reasons. Now in CRPC we had section 354. Generally you should give life imprisonment, and if you give death penalty, then give special reasons. Same is the case with BNSS, we have new section. If we can go and think about the accused person to that extent, why can't we just think about the victim? Because if by chance, if the court does not find the evidence is sufficient, there will be benefit of doubt. We don't have any problem that accused is getting acquitted, but what about the victim? He has to wait. And just see across the country, there are acquittals. Every month there are acquittals. We are not saying that per se it's injustice, but yes, it is waiting of the justice. It might not be injustice, but we are still waiting, and that's the reason we have to find out some kind of provision, some kind of resort where we can infuse that element of restorative justice in our criminal justice system. If not, we have the separate parallel machineries. Variety of sections are flooded to safeguard the rights of the victim, but it is not something that you call as a restorative. Getting information of the proceedings, all these things, we cannot directly say that it's a restorative justice. There requires a solace, there requires some remedy, some compensation in mental, physical way. So flooded, there are so many sections, you can just look at them. I have plenty of slides about that. I will just leave the presentation with organizing team. You can have a look on that and you might study it further. Then we have entire victim compensation scheme in India. Look at the developments. When the offender is not traced or identified, or the trial does not take place, still the victim has to get the compensation. That is very unique thing. That's very good. This might be the beginning of restorative justice in India. See again 396(7). Even if the payment of fine is received by the victim under sexual offences, if it is not sufficient, then victim compensation should be given. For the treatment of victims, variety of things are there. This should include psychological things. This should include counseling. This should include participation. At present, we do not have any psychological assessment or counseling mechanism which involves the accused to treat the victim. Accused is something that we keep away from the victim as much as we can. Restorative justice says bring them together. You might have heard that famous line of Rumi, a very famous Persian poet. He says that pain is the hole from which light enters to your mind. That's how you cannot cure the victim without the participation of accused person or the offender, because that is how the crime has started. So as a medicine, you have to use that, and this might give solace to the accused as well. He might get that repentance, he might get that remorse that I've done it. And we have examples. It is not the case that we did not have. We have some examples in which these things have achieved in India. There are cases. Let me just briefly tell you. Victim impact assessment and role of the victim has been already ensured by judiciary in very many cases. But these are the Indian experiences. We have Sanjeev Nanda's case, a very famous Delhi hit and run case, in which that community service element was given and this particular person was made to compensate. Then we have Mukesh Mukund Patel, a very famous case that in 2025 that case has come, in which the Supreme Court has said that POCSO proceedings to be quashed because now the offender and victim have started their family life. They got married with each other. Of course, POCSO was there because the girl was held to be minor. But this is how the forensic ossification test helped them. And it was proved that at the time of commission of offense, the girl was not minor, she was major. So Supreme Court has recently give this verdict that the squash this POXO proceedings. This is how we are sometimes giving some inclination towards restorative justice, but now it's a high time that we should talk about it openly. We should think what mechanism can be devised for that. Ultimately, I'll just end my presentation with this line by the Supreme Court. Instead of Gujarat versus High Court of Gujarat proceedings, criminal justice would look hollow if justice is not done to the victim of the crime. A victim of crime cannot be forgotten man in the criminal justice system. So with this thought, I will leave you with this discussion in your mind that what can be done, how can we achieve restorative justice, because I personally believe that you might be the architect of it. Thank you so much.